All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. We're here for oral argument in our case number CV24-0220, Deal versus Deal. Counsel, we're recording and live streaming the argument, so please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, if you'll watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, we have discussed this case in conference, so please keep that in mind. And counsel for appellant, you may proceed.
Your Honors, I am Mark Drutz from the law firm of Musgrove, Drutz, Cack, and Gotro up in Prescott, and I represent the plaintiff's appellants in this case. When I try a case, the one thing I expect to happen is that we're given a fair chance, and that just didn't happen in this case. The trial court committed numerous instances of prejudicial error, which are set forth in our brief and that I'll talk about, which justify a reversal. Initially, the trial court refused to give a jury instruction on the statute of frauds, notwithstanding that the defendant's entire defense was based upon alleged oral agreements that he said he had entered into with his father, Norman Deal, that involved real property.
Was an instruction that included the exceptions ever presented?
We submitted, the judge wasn't interested in any kind of instruction. We submitted a jury instruction on the statute of frauds, and we specifically talked about the exceptions of partial performance, but the judge refused to give an instruction on the statute of frauds, even with the exceptions. Flat out refused to do it. We talked about it for numerous occasions. It's well supported that all contracts involving real property generally are not enforceable, and that's why you have the statute of frauds. Yes?
To your comment that the court was unwilling to entertain a statute of frauds instruction with the exceptions carved out, we read from the transcript. You can tell me if I'm misunderstanding. The court said, well, I don't pretend to know every single exception of the statute of frauds off the top of my head, and so unless I have something in writing for proposed language, I'm not going to be weighing in on that. Isn't that the court saying, give me something in writing with the exceptions?
Well, Judge, I'd submit to you that the exception should have come from Mr. Beck, who represents the defendants in the case. There was no question, Your Honor, that we talked about the exception of partial performance. There wasn't any surprise that to the court that was the exception that arguably could have been submitted in this case. We had a statute of frauds instruction. Mr. Beck objected to the statute of frauds instruction and didn't, I recollect, submit his own instruction about partial performance. But that was certainly discussed to this trial court, and the trial court knew that if she was going to give a statute of frauds instruction, as we requested, that Mr. Beck would submit a jury instruction for partial performance. It's not a secret that that was discussed during this trial. She just didn't want to do it. She just didn't think that the statute of frauds was applicable, and we argued the point, and she made her decision, and there wasn't anything that we could do to sway her in that regards. But again, the entire defense that Mr. Brent Deal had in this case was he was relying on these alleged oral agreements that his father, Norman Deal, who was deceased by the time we went to trial, but he had testified in his deposition, contrary to his son Brent Deal, that he had never agreed to trade. And this is what their position is. Norman Deal agreed to trade his equity in all of these properties, which were worth millions of dollars, for some rebuilt cars and 2 lots in the Verde Valley.
Counsel, let me go back for just a second
Sure.
to the jury instruction. The jury instruction on the statute of frauds went to one of the counts that the jury was advisory only. Is that correct?
We wanted the statute of frauds instruction on all the counts. One, we had a conversion count, which clearly covered real property, and we discussed that in our answering brief. And we had 5 other counts which were advisory. But we know from the law, and our position in this case, is that this trial judge just had a basic misconception of what the law is. And there's case law, I've cited it, the Kostolansky versus Lesher case. That's an Arizona Supreme Court case. We've got it in our reply brief, and it says, and I know you know what it says, the rule was erroneous instructions are not prejudicial when the jury is only advisory is limited. The error becomes material when it clearly indicates the court itself was under a basic misconception of the governing law.
So what's the best, where in the record can you point us to that best demonstrates that the court misunderstood what the law is?
Well, I think, Your Honor, because of one, her refusal to give the jury instruction because it addressed a significant issue in this case. The facts supported it, the law supported it, and that instruction that we were requesting on the statute of frauds was not being dealt with by any other instruction in the case. Second, once the jury came back with their advisory decision, she didn't set it aside because she would have recognized that the statute of frauds was applicable. And she never addressed the statute of frauds, whether it was the actual instruction or whether or not she thought, and she was the gatekeeper of the evidence, whether she thought that that exception that we had talked about in front of her, of course, about partial performance was applicable. So she just accepted it, which is interesting when you look at what happened on the unjust enrichment case. On that case, if I might just run over there real fast, on that case, the jury found in our favor on the breach of contract claim, found that there was a contract, found that there had been a breach, but awarded the defendant, counterclaimant, 0 damages. Notwithstanding that, and the fact that the jury found in our favor on the unjust enrichment claim, notwithstanding that, she decided that, well, doesn't matter that there's been a contract and I'm precluded from addressing unjust enrichment damages. She set that aside and awarded $24,500 in damages under the unjust enrichment theory to the defendants.
Didn't your client stipulate, though, on that the court should address unjust enrichment? Or am I misremembering?
I would say, with all due respect, that you may be misremembering simply because the special interrogatories on the unjust enrichment were completely in favor of my clients. The jury answered no to all the questions. I have the minute entry in front of me, and notwithstanding that, the judge decided, really, without, I don't think, any prodding from Mr. Beck, the judge decided that she would throw out the decision by the jury on the unjust enrichment, and she herself would decide that Brent Deal was entitled to $24,500 in damages, notwithstanding the long-standing principle in the law that U.S. Life versus Gutkin, 1986 decision from this court, that the existence of a contract, which the jury found on the breach of contract claim, precludes the awarding of damages for unjust enrichment. So she knew that. So that we argue to you justifies a reversal just because of the $24,500 on unjust enrichment. But going back to your earlier question, Judge Williams, I think it shows that she had a misconception of law. Look what she did on the unjust enrichment theory, and she ignored, even when she refused to give the statute of frauds instruction and the verdict came back and the answers to the interrogatories in favor of the defendant, she still didn't apply the statute of frauds even with the exception. So, and the basic misconceptions of law she has are shown in so many other different ways. One of our arguments are that she allowed testimony from defense witnesses that had never been disclosed. It went far beyond what they had put in their disclosure statement. We brought that to the court's attention. And the court said, quote, "I'll be listening." But we made the objections when these witnesses tried to testify to things far beyond what had been disclosed. One good example is this Lauren Wantland, who was called to testify by the defense. And he was listed in the disclosure statement that he was going to testify to the fact that he had allegedly lent money to Brent Deal to pay off a promissory note on the body shop. But then he went on and he testified that Norman Deal, who was dead and wasn't there to defend himself or say otherwise, had been stealing batteries. Now, what does that possibly have to do with what's in the disclosure statement? It came in for one reason.
Did he say he was stealing, actually?
Stealing batteries.
Is the word stealing?
I believe he did, Judge. Stealing batteries.
Did you make sorry, go ahead, Judge.
I was going to say, didn't he say he came and took the batteries without paying for it, suggesting that they had an easy business relationship, not suggesting he's a shoplifter?
Well, Judge, I guess we can parse the words. Certainly, the impact that I think it had to the jury, it certainly had on us, was that he was contending that Norman Deal was stealing batteries because he was taking them out of the body shop and wasn't paying for them. And why would that have been allowed? What did that possibly have to do with disclosure? I know you're not supposed to script what somebody's going to testify to, but come on. That is so far beyond what he was going to testify to, and we objected.
Sorry, counsel, did you object on relevance grounds or did you object on non-disclosure grounds? And does it matter?
I don't think it matters. It was non-disclosed. We objected on every ground that we could think of to try to bring this judge around, and it was not going to happen. Even when she said she would be, as I said, listening, because she's had the disclosure in front of her. We gave it to her, the disclosure statement from the defendant. And she knew what they were going to say, but she let him go far beyond. And I think that just goes with the whole idea that she really had a basic misconception of maybe what disclosure statements meant, what's fair, how far someone can go and testify to something that isn't anywhere in their disclosure statement. Another example was this rebuttal witness, is that Brent Deal testified on redirect called by Mr. Beck that he was being kept from seeing his mother, Millie Deal, in the nursing home. Well, that was contrary to the testimony of his brother, Aaron Deal. But we wanted to call a rebuttal witness from the nursing home who was going to testify that no, anybody could visit Millie Deal. And the judge refused, even though she allowed them to have people testify to things beyond the disclosure, she refused to allow us to call a rebuttal witness who was going to testify that that wasn't true on the grounds that it hadn't been disclosed. Well, how would we have known that he was ever going to testify, this is Brent Deal, to that fact on redirect, that we would have ever been able to disclose it? She said we couldn't do it. Basic misconception of the law, basic misconception of her responsibilities as the gatekeeper of evidence. She just didn't do it right. Another example, and I can talk more about the statute of frauds, because to me, that's the one that jumps out the most statute. Mr. Beck's going to get up here and he's going to say, because I heard him say it, he's going to say that statute of frauds didn't apply because there were powers of attorney and he executed deeds, Brent Deal, conveying the properties out of his parents' name into the name of his trust. So you have a writing and it doesn't apply. That absolutely ignores the underlying premise of why did he do it? Why did he think he could do something like that? He thought he could do it because he already owned the properties. The fact that my clients' names were on them was meaningless, and that the fact that he had oral agreements absolutely, he contends, entitled him to do it. And the jury didn't know the fact that the law in Arizona says oral agreements generally aren't enforceable. Never heard that, just thought it was a family squabble without any real connection to what the law is as to oral agreements on real property, and they made their decisions on that basis without being tuned in to what the law is. And the judge is the one who made the decision not to tune them in. The judge accepted their findings and then didn't reverse that, notwithstanding the fact that she reversed the unjust enrichment finding by the jury. I've got 2 minutes left, a little bit more. I wanted to reserve some, but I want to answer any questions you might have. Thank you very much.
Good afternoon. My name is Andrew Beck. I represent the defendant, counterclaimant, appellee, Brent Deal in this case, both at the trial court level and before you now. Let's start with the statute of fraud, since that's where my opponent started with. I think there are several reasons why a statute of frauds instruction was not required, but before we even get to that point, the question is, even if it was required, whether that can lead to reversible error. The case that Mr. Drutz cited to you, the Kostolansky case, was actually cited for the first time by me in our answering brief, and there's a trio of cases there, Decker v. Romanovsky, Ottenreith v. Norville, and the Kostolansky v. Lesher case. Those are all Arizona Supreme Court cases, and they all stand for the same proposition, that an improperly advised, improperly instructed advisory jury cannot result in reversal unless there is evidence that leads you to believe that the trial court judge was under a misconception of the law. I would note that in their opening brief, there is no argument that Judge Wallace was operating under a fundamental misconception of the law. The argument was that this is reversible error because the jury was improperly instructed. Of the claims that were brought in this case, all of them were decided by Judge Wallace with the exception of the one claim, the conversion claim, and there were actually two. There was one by each of the plaintiffs in this case had made a conversion claim, but the other claims, financial exploitation of a vulnerable adult, 46-456, decided by the judge, breach of fiduciary duty, decided by the judge, unjust enrichment, an equitable claim, decided by the judge, and then quiet title, which was really more of a remedy than an actual cause of action itself. All of those were decided by the court. The only binding finding that the jury made, at least as far as the plaintiff's claims were concerned, was the conversion claim. And our argument is that you can't...
And the breach of contract.
We had a breach of contract claim, a counterclaim against them.
Right, okay.
They did not have a breach of contract claim against us.
That was a binding jury verdict.
That was, and I'll certainly get to that when we get to that portion of it. But of the claims that they brought against us, only the conversion claim was a jury-eligible claim or a jury-required claim. Conversion is interesting because, of course, as we know from Miller v. Halen, from Madison v. Groseth, conversion only applies to chattels. It doesn't apply to real property. There is the exception in the law where money can be the subject of a conversion claim, but only where it can be described, segregated, and there's some sort of obligation to treat it in a certain way. That test is from the Ottoville v. Friedman case. So what we have here is a situation where the one claim that the jury actually decided is the one claim that I would argue cannot be based on real property. You cannot convert a house. You cannot convert an empty lot. You can convert money, but only in the circumstance where that money has been specifically described or segregated or can be kept aside. And in fact, we had filed a Rule 50 motion at the end of their case, arguing that that conversion claim was not viable because there was no evidence received that there was some obligation by my client to treat the funds of one of these real estate sales in a particular fashion. Judge Wallace denied that. She allowed it to go to the jury, and the jury found in our favor on that conversion claim. But the fact of the matter is, Your Honor, even if there was some requirement to instruct on the statute of frauds, that's not reversible error. But I think when we take a step back and we look at the statute of frauds itself, I don't believe any instruction is appropriate here because the statute of frauds does not apply. The statute itself says no action shall be brought, ... unless the promise or agreement upon which the action is brought is in writing and signed. Our Supreme Court has said specifically that the statute means what it says. In the Brott v. Howard case, 1926, the court saying oral contracts are not void under the statute of frauds. It simply says no action shall be brought on an oral contract. They simply, quote, cannot be enforced or made the basis of an action for damages if the party sued raises the objection. That holding is still good law. It's been cited by this court as recently as 2000. And the statute of frauds simply does not apply here because my client, Brent Deal, was not bringing an action to enforce a contract. He was defending claims being made against him. All of these transactions that were testified to at length during his direct examination were transactions that were fully performed years or sometimes decades before. There was nothing to enforce. My client was not out trying to enforce an oral contract. He already had good title to all of these properties. All of these transactions had been completely performed. And I tried to come up with an analogy here that I think illustrates the difference between where the statute applies and where it does not. And I'll let you decide whether I've come up with a good one or not. The statute of frauds also...
Before you go there.
Sure.
Okay, so what you just said for the last couple of minutes, and as you're explaining this, and I appreciate that, did you make those same arguments to the Supreme
I did.
Court?
To the Superior Court, yes. I have argued consistently not that the statute of frauds instruction that they suggested was improper or not correctly written. I argued that no statute of frauds instruction was appropriate at all, simply because it is limited to situations where plaintiffs are trying to enforce an oral contract. We are not trying to enforce anything. We already have title to these properties. We are not trying to enforce a contract because the contract had been performed long, long ago. So if I can give you my example. So Judge Brown, let's say that I say to you, I will buy your car for $500. Under the statute of frauds, section 4, contracts for the sale of goods of $500 or more, subject to the statute of frauds. You say, I accept, I come by your chambers the following day with $500, ask you to give me the keys and the title, and you say, no, I'm not going to do that. And I bring a lawsuit against you to enforce that contract. I'm out of court. I'm going to lose because I have to have that agreement in writing. If, on the other hand, we go through that same factual scenario. I come to your chambers, I give you the $500, you sign the title to the vehicle, you give me the keys, I go down to the parking garage, I drive out of here, and that's my car for the next 5 years. And then you sue me for return of that vehicle. You don't get to use the statute of frauds to prevent me from describing the transaction that occurred. That is not what the statute is designed to do. I'm allowed to testify that I gave you that $500, that you signed the title over to me, and that you gave me the keys, because it is a fully performed contract. I'm not trying to enforce anything. This is a description of a fully completed transaction that took place, in this case, many years ago. If I can, I'd like to move on to their, well, as a matter of fact, I'm happy to go wherever the court would like at this point. We have 6 different arguments. I have limited
Let's talk
time.
about your breach of contract counterclaim and
Sure.
unjust enrichment, if you don't mind.
So I want to make it clear that we have conceded from the beginning that our breach of contract claim against them and our unjust enrichment claim against them are mutually exclusive. I can't win on both, because one of the elements of an unjust enrichment claim is an absence of a remedy at law. Obviously, there's a breach of contract, there's a remedy at law. We've conceded that point from the beginning. What happened was, and what these claims turned on, is they were, my client had done some work on a piece of property that his father, Bud Deal, had owned. My client testified that his father agreed to pay him for that. He never did pay him for that. And so, thus the 2 claims. The jury came back with a verdict that said, we find in favor of counterclaimant Brent Deal, my client, against his parents on the breach of contract claim, and find the damages to be $0. At that point, where we actually had that discussion with the court, the jury had already been excused. We had already let them go. There was no going back to fix that verdict. And I was not able to find a case that's analogous to our situation, but there are cases out there in Arizona where, for instance, a tort plaintiff has had a verdict come back in favor of plaintiff but find damages to be 0. This court and our Supreme Court as well, I believe, have said that's an inconsistent verdict because damages are an essential element of a tort claim. The same with a breach of contract claim. And what the jury was instructed with here was, and the instruction itself is on page 5 of the final jury instructions at Index of Record 117, that in order to find in favor of my client, you must find 3 things. 1, there was a contract with Norman and Millie Deal. 2, that Norman and Billy Deal breached the contract. And 3, that breach resulted in damage to Brent Deal. I recognized when we had the discussion with the court that this is an inconsistent verdict. You can't have a plaintiff winning on a breach of contract claim and have 0 damages, because damages are an essential element of that tort. And so I simply conceded the point. I said, Your Honor, you should enter judgment in their favor on that claim because it's an inconsistent verdict. You can't have 0 damages. And that was not gamesmanship on my part to try to get to the unjust enrichment claim. That was me conceding the point, essentially. The jury's already gone. We can't fix this. So I conceded that judgment should be entered against us. The other side obviously agreed, and we went on our merry way. And then a month later, Judge Walsh issued her findings of fact and conclusions of law and awarded us damages on the unjust enrichment claim. We did not ask for that. That was not briefed. I did not expect that. I'm quite certain that my opponent was just as surprised about it as I was. But the question really boils down to, what did the jury actually decide? Their interpretation of the jury's verdict is that they must necessarily have found that there was a contract and that it was breached, but that it didn't result in damages. If that is correct, my argument would be that the correct verdict to enter was a verdict in their favor, not in our favor with 0 damages. You have to have damages in order for us to be successful on that claim for breach of contract. And so given that it was inconsistent and muddled, I again conceded the point, allowed judgment be entered against us on that claim. Judge Wallace determined that the just thing to do on that was to award us damages under unjust enrichment. Can you read the jury's verdict the way Mr. Drutz reads it, so that they were finding yes as to questions 1 and 2 and no as to question 3? I think you can read it that way. The question is that the only way to read it? Or is it instead a product of a hopelessly confused jury, or a jury that's confused about these particular instructions, and therefore my concession of the point and judgment being entered against me wipes out any findings that the jury made?
If we have an alternative on how to interpret the verdict, why wouldn't we presume that the jury did the right thing or knew what it was doing? Why would we presume that they were confused?
I don't know that there is good case law on which presumption should apply. I have scoured and trying to find a case where we have a similar factual scenario. I have not come up with anything. I don't believe my opponent came up with anything squarely on point either. The question, I think, is my concession of the point and the stipulated entry of judgment on their behalf on that claim, does that wipe out the factual findings, to the extent that they made any, that the jury made on that? And I am here telling you I don't know the answer to that. I don't have a good case that answers that question. It may be a brand new issue. I'm not entirely sure. But what I will say also is this. If you conclude that the jury necessarily made those findings and that my claim for unjust enrichment is precluded, you can simply vacate that. There's no need to remand. There's no need to go back and do a new trial. That is simply something that can be wiped out on remand, or simply vacated by this court without us having to go any further and do this over again. I've got about 6 minutes left. Is there another particular subject that the court is interested in that you'd like me to address? We haven't spent any time on the dead man statute. We did... If I could, I'd like to talk a little bit about the disclosure issues and some of the things that Mr. Drutz brought up. I think if you look at the trial transcript as a whole, particularly the transcript of days 5 and 6 of the trial, which is after these disclosure objections were made, I think you will find Judge Wallace sustaining an overwhelming majority of those objections. They didn't bring all of them up in their brief, but it was very clear, and Judge Wallace made it very clear to me, that she was not going to permit testimony that was undisclosed. Keeping in mind, of course, that disclosures are not merely what you put in your initial disclosure statement, but it's also information that's disclosed through depositions. It's also information that's disclosed through discovery responses. I'd address those issues with Judge Wallace. But the fact of the matter is the disclosures in this case were inadequate. That's my fault. I came to this case very late. I was brought on when prior counsel went to go work for the county attorney's office. So I came in a few months before the trial, but I made the mistake of not updating the disclosures and providing a more fulsome disclosure of what some of these other witnesses were going to say.
You would concede that Judge Wallace did let in some testimony beyond the scope of what...
I don't know that I would concede that, and if I can, I think the devil is in the details here. They've identified 20 different instances in their brief, and that's on pages 28 and 29 of their opening brief, where they believe that there was a violation of the disclosure rules. Of those 20, 5 of the instances, the objection was sustained, so the evidence didn't come anyway, so we're down to 15. Leaving with that 15, 3 of the instances, there was no disclosure objection to any specific testimony. It was just, I object to any disclosure outside of the testimony, and that was it. There was no ruling on it. It was simply a general objection that was stated. That leaves us with 12 instances. 6 of the remaining 12 instances, significant testimony was already received on that subject without objection, and then an objection was made right at the end after the testimony had already been discussed at some length. We would argue that those are waived. So that leaves us with 6. Of the 6 instances, in 3 of them, the witness did not even answer the question, or the witness said, I don't know, or I don't have any information about that. That leaves us with 3. One was, the question that was asked was, tell me about your relationship with Brent Deal. That was one of them that was overruled. Judge said it was foundational. I agree. How do you know this person? How are you related to this case? The second one was a question to witness Mike Visser about where his business was located. Okay, again, what's the prejudice there? And the last one was, towards the end of his life, did you notice any changes in Bud Deal, who is Norman Deal? 3 other witnesses had already testified at length about that subject. So what we're left with here is, to the extent that there was anything that was not disclosed that was offered, there is no prejudice. They have not articulated any reversible prejudice from any of those things that we just talked about. In fact, the stolen batteries, and I'm glad you brought that up, the objection to the stolen batteries testimony was relevance and non-responsiveness. There was no disclosure objection to that testimony, and I didn't ask him about batteries. Mr. Wantland, Lauren Wantland, 70-something-year-old man who was at that point in his life where he liked to tell stories. So it was, how do you know Brent Deal? And he would go for 3 or 4 pages of transcript, unless one of us reeled him back. He was all over the place and wanted to talk about everything. I didn't ask him about batteries. He brought that up on his own. There was no objection to the disclosure of that. So I did ask a follow-up question about the batteries, again, because it was already in and there was no disclosure objection. But I think when you look at the entire trial as a whole, what you see is Judge Wallace vigorously enforcing the disclosure rules, vigorously enforcing her rulings about what was going to come in, what was not going to come in.
Do you think it's a fair import of the testimony that was given about the batteries, that Norman was stealing batteries?
I don't know that stealing, I would say it was not a favorable inference. I will say that. I think really what it came down to is, Bud Deal was a bit of a character, and you heard that from all the witnesses that came through the trial, and that he was a sort of a complicated guy that, did good things sometimes and did bad things sometimes, and had taken these batteries. But again, we didn't focus on the stealing of batteries. That was not something we spent any time on in this case. It was an offhand comment made by one witness that, again, no disclosure objection was actually made to. Given that circumstance and given the trial as a whole, they make no argument about what they need to make in order to get a reversal on a disclosure violation. And what they have to show...
Was there a motion to strike made about any of the disclosure issues?
I don't recall any motion to strike, and I don't want to misrepresent the record to you. So it may be that there were motions to strike 1 or 2, but I don't think there were a lot of them. If there was, it was 1 or 2. But what they need to show is that this undisclosed testimony prevented them from preparing for trial, that it did not allow them to have a fair hearing. And when you really break down those 20 instances and look what they actually preserved and what was actually complained of, it just isn't that. And they don't make that argument in their brief that they were fundamentally denied the right to prepare for trial. And I see that I'm out of time. Thank you very much.
We had a continuing objection to the court regarding this non-disclosure. We brought this to the court's attention repeatedly, that these witnesses were testifying far beyond what had been disclosed, that it wasn't fair to us, and the court overruled the objections. The record says what the record says, but I was there, and that's what happened. Going to the going back on the statute of frauds, the statute of frauds clearly applied to our conversion claim. The jury instruction that we got on conversion says that wrongful dominion or control over money that constituted personal property, and here's the key, as a result of Brent Deal's retaining the sale proceeds from the sale of real property in which Millie or Norman Deal had an ownership interest, clearly tied to the real property. Jury didn't know that you should not have oral agreements, as Brent Deal was arguing he had, and that it should have been in writing. Mr. Beck's argument basically is, well, the theft had been completed years before, so we didn't have to bring an action ourselves. What if the shoe was on the other foot and he was trying to enforce these oral agreements? Wouldn't the statute of frauds have applied? Of course it would. It's a distinction without a difference. His entire case, his entire justification as to why he could use power of attorneys that his parents executed to him, and then the very next day use those powers of attorney to convey his parents' interest in properties that were worth millions of dollars just to Brent Deal's trust. One of the properties, the Black Hills properties, had originally just been in my client's name. They bought it. They spent money putting improvements on it. And even after that, then they put Brent Deal's name on it. And yet he contended at trial it was meaningless how his parents' names may have been on the title. It belonged to me. I could do whatever I want with it because of this oral agreement that he contended with his father. Any questions that I can address? I haven't talked about the dead man statute. It's just another example of the judge overruling objections that we made on hearsay, dead man statute grounds. He allowed Brent Deal to testify as to what Norman Deal said. Norman Deal's deceased, wasn't there to controvert it, although he had said in his deposition there were no such thing as these oral agreements. Judge let it in. We asked for a curative instruction. Judge refused to give it to us. Another example of the court having a basic misconception of how the law works as to evidence and as to the jury instructions. I'll end with the fiduciary duty. The court should have crafted a breach of fiduciary duty that pertained to the specific facts of the case. Refused to do so. Refused to do anything other than give the reasonable man instruction, notwithstanding the jury instruction saying it should be modified to meet specific facts. Thank you very much, Your Honors.
So thank you both for your arguments this afternoon. The matter is taken under advisement and will issue a decision in due course.